object. That's our privacy rule. So I hope not too many will object, because I like to see all those panels appearing on the internet too, and to share it with the world at large. It's about sharing with the world at large that we are here, at least for the first panel. This is a very ambitious opening night, and we have two excellent panels, and we are very strict on timing. 30 minutes for the first panel, 1 hour for the second panel, which is a panel that should not be missed. This evening is organized with Nym Technologies and the Brussels Privacy Hub, together with CPDP. It's a pre-event of CPDP, and it is famous for its more chaotic style, and as you know, CPDP does not do keynotes, and this is with the pre-event. We impose that format on the pre-event, but the people, every person speaking this evening should deserve a 1 hour keynote, and they will not have it, but in my thoughts they will have it. So what are we doing? We are CPDP. This is the 15th time we're doing it, and we are actually, like you, coming back to a certain normal and hoping that the privacy community is still there, is still active, is still alert, and that the discussions that we used to have with each other will go on with the firstness and the intensity that we like. None of the panels will be one-dimensional. They will all be plural, and if not, complain. We like gender balance. We like disciplinarity in balance in disciplinarities. We like geographical balance, because Europe is not all-knowing, and we don't do better than the rest of the world in many things. And more of this I will share with you tomorrow morning at 8:30, because then we start. There are 80, 90 panels, more than 450 speakers, so probably all of you are speaking tomorrow, and there are also a lot of participants non-speaking, but we will give them the floor too as much as possible. Stay with us for the two panels. I insist, they're both really good, and I love all of those speakers. Stay with us for the cocktail, because it's a good one, and we don't charge money for it. We're so happy that you're here. And without further ado, I want to quickly tell you about the first panel. It's of Chelsea Manning is amongst us now, having many heads and activities, but one of them is working with Nym Technologies. We have Bart Preneel from KU Leuven, who is a computer scientist that is with a reputation that goes far beyond Belgium. And we have a CEO of Nym, Harry Halpin, that has been at CPDP several times, and that made him the ideal person to moderate the upcoming panel and to keep time, but also to make sure something is happening in this panel, but it will. Thank you, and good evening.
So, welcome everyone. The title of this panel is Privacy Against Power. So, I first became interested personally in privacy due to being targeted by surveillance by the British police, a case I discussed here, and of course interested in how cryptography and regulations can prevent the abuse of power. In fact, over the last few years, what is Nym? Over the last few years, we've researched how we can enable privacy-enhancing technologies. Nym is a company which is effectively commercializing a mixnet, a stream of research that Bart, with Claudia Diaz and other people, were very instrumental in more than, I would say, 20 years ago, building off concepts from David Chaum and how to build essentially anonymous communication systems which are resistant even to very powerful adversaries. And our work was presented actually right before the COVID crisis at the last CPDP in person, where we talked about how the EU was interested in trying to fund technologies to essentially prevent NSA-level surveillance. But since then, a lot has changed. It's been a crazy 2 years. We've had COVID, contract tracing, vaccine passports, a lot has happened. And I think the question of privacy and technology and regulation is more important now than ever. So I'd like to ask Chelsea Manning, who I think through her actions demonstrated the power of a single individual to reveal truth to power, to the most powerful government in the world, the United States, in terms of the Iraq War. Chelsea, what do you think are the kind of positives and negatives of privacy, including technical and kind of regulatory approaches to privacy?
All right, so hey, how's it going, everyone? I'm Chelsea. I think that whenever it comes to privacy, I think that historically, privacy has been viewed as like a physical thing for most people. So whenever you think of, whenever you think of locking a door or shutting your windows, right, or putting up a curtain or closing the door or having fogged windows, like for like your bathroom or whatever. Privacy is a very physical thing: locks, keys, etc. But I think whenever it comes to digital privacy, I think that people have had trouble wrapping their head around the importance of privacy in this realm until very recently. And I think that, in particular, because I think I was reading something about how in 2019, most places that had a lot of broadband internet, so United States, Western Europe, Brazil, parts of East Asia, and Commonwealth, sort of British, former colonies, that all had a lot of internet access, were surveyed in terms of like their internet use. And it was found that approximately 9% of people were "quote unquote" extremely online, meaning that they spend more than a certain number of hours online. But that jumped up by late 2021 to around almost 30%. 29%. So by there's 3 times as many people in the last 2 years who are now "quote unquote" extremely online because of remote learning and remote working and things like that. So I think that people are starting to feel the exhaustion of that, of having their information exposed, of having that webcam on, of having every single interaction and be over electronic means, and be reviewed by coworkers, bosses, your professor, your teachers, and whatnot, and have all these different applications and everything. And then also in your free time, then be having your data still be collected when you're on social media and interacting with people off of messaging apps and things like that. So I feel like there's a psychological sense between people of an alienating effect, but between having your communications over electronic means and also not being sure when that information is being used, whether or not it's going to be screen capped by somebody who's a partner of you, or who you're discussing things with, or whether or not it's somebody who intercepts a communication or a picture or something like that, or whether it be a "quote unquote" bad actor like a hacker or a surveillance apparatus, or if it's just simply your boss or your professor. So that's my sense of things, is that privacy has, I think, increasingly been recognized as something important.
And just
digital privacy in particular.
Have you found that in your personal life, has privacy enhancing technologies been the kinds of technologies that you've had to rely on at all?
Yes, I certainly, but I work in this space all the time and I depend on it, so it's very important. But I still scroll on Twitter and TikTok. I still watch a lot of TikTok videos. So there's a give and a take. There's a threat modeling that's taking place in terms of like my security.
And welcome to Europe. And I also would ask, I'd like to know. We have Bart Preneel here, probably one of the most prominent cryptographers and also one of the proponents of post-Snowden cryptography that can deal with these sort of surveillance attacks that we've seen. And I think the question I have for Bart is, what is going on in the European space and the Belgian space as well in terms of privacy and the new regulations coming around?
I think we've seen some gradual successes. More and more people get worried about privacy and adopting secure technologies, like we have now secure messaging, end-to-end encryption. You may have seen a few years ago the Commission announced that they were going to use Signal themselves, which is actually open source, and it's not a commercial tool. It doesn't actually collect advertising. I mean, some people criticize Signal, but I think from technology point of view, it's definitely the most solid solution. It's actually also the inspiration for WhatsApp. And by the way, the Signal founders were not so happy with the Commission adopting this tool, because Signal is off the record, which means there is no evidence remaining for your conversation. And you can actually argue whether people in power should actually have access to this as their default tool, that they can actually talk off the, I mean, they have the right to talk off the record, but should they have actually, as a recommended tool for them, something off the record? That's more a legal question, I think, than a technical question. But that was kind of the good developments. We see Nym coming. But then if you actually look at what's happening in the past years, we're going back the other way. I mean, the big proposal that was in the news recently is something what is in the making for a while, is the client-side scanning. So what happened is that the Commission very slowly started consultations 2 or 3 years ago with several groups about what can we do. The motivation is CSAM. I never had heard of this word when I was in the consultation, but CSAM is child sexual abuse material. This is, of course, a very serious problem. There is horrible material out there. And so, for some reason, the view has emerged that you have to solve this problem by scanning the end systems, right? So it's, in fact, end-to-end encryption stops police from doing their work. That's the bigger story. And the reason why the Commission got interested was actually that Facebook was going to offer also end-to-end encryption for their messenger application. And apparently hundreds of idiots were sending very sensitive information over Facebook without end-to-end encryption. So they never used WhatsApp, they never used Signal, but they were caught like this. And so the story was that if we're now going to add end-to-end encryption to Messenger, then we will not be able to, we go blind, we go dark. That's the story we always hear. So what happened is now this has become very concrete. The Commission has now made a proposal and said, to all the players, you have to do this. There was a report that was heavily criticized, where technical people said, these are the options. There's many ways to do this. And it's already happening today, for Facebook it's happening with a certain tool. But we also told the Commission as experts, and don't even think of doing this, but that part they left out of the report. So there is many ways of doing this, but there is no way to do it and protect society. Because the problem is that what you're going to do is you look at your device, you take not a picture or a video, but a hash of something, so nobody knows what it is. It turns out to be also an insecure hash, which means somebody can plant something on your device that actually is not CSAM material, but looks like it, and then you actually will investigate it. But so based on this hash, you will be flagged. And what we've been saying as technical experts is, don't think of doing this, because, of course, think of Hungary or some other country. They also have some content. That's not CSAM, but some other content that they don't like, and they will put it in the hashes as well. And they will also flag people. So in fact, Europe, driven by police forces, is now pushing for rolling out a system that all dictatorships will love, because it will allow to pry into everybody's devices and filter out those people who have something they don't like. And maybe as last story is that last August, Apple came with a solution for this, even without being forced to do it. It was a very nice technical solution. It was very cool, but again, it could be abused. I mean, from a technical point of view, it had many safeguards, but the main thing is such a thing should not exist. That was actually not taken into account. And so, of course, Apple got big backlash, and they withdrew their proposal. But I think the debate is now more or less, again, the same thing as Clipper chip and elder debate coming back. Commission said to technologists, solve the problem. Technologists and big companies solve the problem, and we say, first, it's not solvable, and second, we shouldn't solve it this way. There is a problem with CSAM, but you have to deal with it in a different way. And in general, those people sharing this material, they're not the smartest cookies. You probably can find them in other ways than putting spying devices on all our iPhones and all our Android phones.
And Chelsea, I mean, you've been involved, or at least are watching some of these debates from the United States. What is going on in the US in terms of client-side scanning and end-to-end encryption?
Yeah, so I think client-side scanning, obviously we had iMessage and Apple. There was a controversy with that very recently. I think that a number of people in the security space are expecting the United States government to force, client-side scanning more and more, and to essentially enforce some kind of backdoor where there's a key in the long term for people to be able to access encrypted communications going through end-to-end encryption. Doesn't quite work like that, you know. If you get a backdoor, then it just lets everybody through. So I think that's obviously going to be a controversial problem, but I think politically it's a winner in Congress right now, and in many of the state legislatures, among the legislators. It's like one of the few bipartisan issues that's out there, and bipartisan things in a highly polarized environment like this tend to be a red flag to me. So I think that we're going to see more and more very uncomfortable from a privacy perspective laws coming into the U.S. You know, over the next year or two. So I think that those are definitely in the pipeline. The legislative environment is going in the opposite direction from where it has been in the past, and I think that a bit larger companies are seeking solutions now on the back end about how to come up with ways to try to at least appear to be more secure and more private.
I mean, as an American who lives in Europe but does visit the U.S. a lot, I would say that the people in Europe should not underestimate the chances that Biden will lose the next election. And it's not the government you have now that you might need to be worried about, it's the government you may have in the future. And I'm sure Trump would have a very different definition of offensive or offensive material than maybe people here would expect a government would have. And I think the real question is, I mean, what powers should a government have? How should they be regulated? And I'd like to kind of throw the issue back to Bart. You know, we've had a huge fight against mass surveillance provoked by the United States in Europe. What is the current state of that debate within Europe right now, and particularly Belgium?
Well, of course, this blind-side scanning is only one part of the debate. It's been a very interesting year, actually. So there is also the data retention carousel, as we can call it. As a technician, I'm actually appalled by this. I think if you have a law and then it goes to the highest European court and the court says you can't do this, you would think then, okay, politicians decide we can't do this. No, it seems to be very different. I'm learning. What you do is you tweak the law a bit, and then you actually submit it again. It seems to be able to get it to Parliament, and then another battle of 3 to 5 years to get it destroyed. So it's a bit like Schrems. I think that the problem is we have to invent new names for all these things, because these carousels, I think, at least to me, they make me very cynical about the political process and about the legal process as a technology person. So what happened in Belgium is that the government was told that collecting all metadata about everybody is not acceptable. So they said, okay, we'll not collect everything about everybody. We're just going to collect in a certain radius around every hospital, every prison, every train station, every airport, every dangerous place. And so if you draw the circles, you will have, there is a few places in the Ardennes where you can probably be safe, but all the rest of Belgium will be anyway high risk alert. But then something more interesting happened, because in the back of the law, everybody's already exhausted by the time they get there. In the back of the law, they said, and by the way, we're also going to forbid end-to-end encryption. And then they were confronted about this. They got some backlash from the organizations, and then they withdrew this part. But then something else happened, and this had not received as much press attention. So then, apparently there is a new, and I'm not a legal expert, but there's a new European regulatory framework, and now the services to which data retention applied are being extended. So because the definition of a service is now extended, so now data retention also applies to Signal, WhatsApp, and all the others, so also over-the-top services. So it was first something for the telcos, which you could avoid easily by using WhatsApp or Signal. So now actually it's being forced up also on all the apps. And then this becomes very technical debate, because then they say, well, you shouldn't collect more data than you collect anyway already, but of course it's very unclear whether Signal will be forced to collect more data about you than they did before. And again, when I was reading this draft law, there was an extra surprise at the end. As surprise detail, they also added an interdiction of systems like Tor and Nym. So in fact, hiding metadata deliberately also became illegal. And this is the package that went to, at least I saw part of it as member of the external expert in our Privacy Commission. I don't know what happened in detail in the Parliament. I have another job as well. I can't follow all the debates. I only know that the whole package submitted to Parliament was more than 800 pages, with all the versions, and of course there is in Belgium is the two language versions, but all the comments given. But I even wonder how many experts already have read these 800 pages, and how many have understood them. But in general, as a technical person, I find it very tiring that this kind of techniques are being used. And then also, the second fact is that they try to set Belgium apparently as an example. They try to use maybe the chaos in our legal process, and the fact that maybe there is not enough activism, at least in Belgian society. We have quite some organizations here, but they're usually more interested in what happens at the Commission level and not so much at the Belgian level. But so they want, I think the end-to-end encryption ban, that has been removed as far as I understand, but I'm not the best informed, but at least the draft I saw still had a ban on using services that hide your IP address or hide your location, which is kind of, I find it shocking. And the argument, if you talk to the people, is, well, Belgium has to set an example to the rest of Europe. We know that we are the only ones. Of course, in practice, Signal and Nym will just have to remove Belgium from their services and move on, but they believe that they will set the example for Europe, the shining light for Europe in the first nation with less privacy than any other EU nation. So I find this quite surprising and shocking, and I hope something can be done about this.
Yeah, I mean, Nym is a Swiss-based startup, but we do have employees and are registered in Belgium. So I hope that I can come to this conference next year without being arrested. And Chelsea, so what is your opinion about? It seems like some of these regulations to defend privacy are being undermined. What do you think we should do?
Ignore them. I mean, no, I'm serious. I think that ultimately, at the end of the day, if somebody tells you that you can't do something in a hostile country like, say, China, whenever it comes to like China or Iran, historically it's been like, oh yes, you just do the things and you go around it and you find ways around it. Well, I mean, if that's a Western country, then the same thing applies. You use the tools anyway, and we as technologists try to ensure that there is a extra legal, jurisdictional method in which you're able to continue to maintain and have your privacy. So in essence, if you are forced into piracy, then you become a pirate.
I mean, I do think that is definitely, if I guess if encryption becomes illegal again or resistance,
yes.
Then I guess only outlaws will have encryption. And we've been fighting this battle for 30, 40 years at this point. So, I mean, Bart, what do you think the role of the EU should be?
Well, I find it hard to read. On the one hand, I mean, I'm very happy to see things like GDPR, although enforcement, I think, could be better and more funded and more strategic. There is e-privacy and e-privacy regulation, if it ever appears. I think in general what we see is positive things. Europe wants to be the role model for the world, and it seems also, I think GDPR has to some extent had this effect. But then there is also the other side. So Europe also seems to be at the same time also be the first in the world to have regulation. They're apparently competing with the US, have the first to have this client-side scanning regulation. I think in data retention, Europe is actually leading, because in the US, data retention against US citizens is forbidden. It is not allowed. I mean, this is one of the things in the Snowden documents that actually gave quite some outrage. But apparently in Europe, we have this in our directives, and we implement this. And we still see ourselves as privacy examples, but in fact, there we're not. And so the main problem I see is that it's very hard to have an open debate about these things. In the sense, of course, there is all the there is the legal process, the very complex process at the EU level. There is, of course, consultations. But I think in general, it's very hard to have an open debate in the public space about this. There seems to be not enough attention. And so there's this kind of these Janus heads, on the one hand pushing for privacy, and on the other hand pushing for technologies that undermine privacy. And like this, it's one commission, right? Where are you standing? You can't have it both. You can't say to the police that you're going to look at every phone, and you can't say to the rest of the population, well, there's GDPR and you're protected. It's kind of, they have to take a view on this, and it's very hard, I think. It's very hard debate, and I think I'm actually concerned that Europe is sliding away in the wrong direction.
Typically, I used to work for the World Wide Web Consortium, trying to essentially, and in the nonprofit sector, and we often consider that the largest threat was the private sector. And so the research that founded Nym, mixed nets through panoramics, attribute-based credentials, Bart helped lead that with Prime Life and ABC for Trust. Nym is still partially funded by the European Commission Next Generation Internet Initiative to work on privacy-preserving identity solutions. However, we're hedging our bets at this point. If the European Union itself becomes hostile to privacy, we're based in Switzerland, and currently, actually, most of our funding is based from cryptocurrency. And cryptocurrency itself, you have laws saying that, well, any amount of cryptocurrency should require full identification of both parties on both ends of the transaction, which is not actually the case with small banking transactions or cash, obviously. So, we're watching the space very carefully. And I would say, Chelsea, what do you think the future of these technologies and funding and popular support for them should be if indeed the governments do make them illegal, or at least very hard to get your hands on, let's say?
Yeah, I'm going to go back just a little bit because I think it was interesting that you pointed out that previously we identified the private sector as sort of being the privacy issue, and I still think that's the case. I think what has happened here, though, is that the private sector, it was really the private sector that was shielding privacy for people in the mid-2010s. Certainly, they viewed it as a very client, a customer, trying to keep customers happy. Apple fighting, legal battles in order to, they were mostly symbolic legal battles in the United States, but still, the appearance of fighting for privacy in the digital space, whenever it came to the warrants and subpoenas and things like that. So private companies have allowed the governments to just sort of move on and move past this. So I think that's what is happening here is that the private sector has decided, well, these are really complicated issues and the government wants to make it our problem if they're not solved. And the best way to absolve ourselves of liability is to let the governments take care of it, and then have them deal with the scandals whenever some horrible tragedy happens, or some significant number of events happen, in terms of terrorism, child pornography, digital. Obviously they have an interest in identifying people who are sharing, there's been an increase in piracy since we have 20 streaming services now, and every single one of them costs too much. So I think that's sort of what has happened and what has enabled this sort of environment to happen, is that the private sector stopped caring about privacy, mostly for legal liability reasons and public relations reasons. Now then, what does that mean for the future? I think that nothing has changed. We're having the same debates since the 1990s. The crypto wars aren't over. They've just been coming in and coming go, and they've been sort of flaring up, and then it just dies down for a little bit. Is what we've seen over the last 30 or 40 years. And I think that the ultimate, my ultimate perception of these things is that, at the same time that a number of these laws and regulations are coming down the pipeline, the ability of governments to really control people or to have the projection of power that they have had in the past, the assumption of institutional legitimacy and control over things, has greatly diminished. We've seen this. And not always in the best ways. We've certainly seen this whenever it comes to a public health crisis like COVID, where misinformation, disinformation was spread, and the election in the United States, where misinformation and disinformation essentially led to the perception among a large number of people that the elections were illegitimate. So I think that people opposing institutional power for reasons good and bad is going to be increasingly the norm. At the same time that a number of these laws and rules and regulations will be implemented, and it'll be about enforcement. And I imagine that that the states will eventually just go back to doing what they've always done and selectively enforce it against, people that they view as opponents, as opposed to actually going after, large swaths of people.
So selective enforcement against activists like Chelsea and Ola Bini, who's currently being selectively enforced against Ecuador, Julian Assange, who's currently being extradited from the UK to the US, and many others. I would, particularly throughout the world and in the global south as well. But I would everyone here is mostly a mixture of lawyers and academics and others. Bart, what do you think the role of academia and the kind of civil society should be facing these issues?
I think it's definitely essential that we try to join this debate, because it's a very complex debate, both from a technical point of view and from a legal point of view. And I think if the academics don't get involved, I think it's more or less hopeless, because my experience also is that, like in Belgium, there is, even at the government level, very little expertise to deal with these questions. They settle the answers, but in fact they don't understand the fundamental issues, neither technical or legal, I can imagine. That's less my expertise. I think it's important to convince academics to get involved. Of course, it's much easier as academics to write papers, because that's what we paid for, and we have now the bean counting systems where the papers are being counted. And I think getting engaged in public policy is definitely, I see this at least in engineering faculty, is not seen as something very positive. In sense that it's kind of, well, this guy talked to the media, rather than doing his research, right? They think he could probably write more papers rather than talking to the media or trying to write policy documents. It may be different in the legal world, where there is, I guess there is a closer connection to policy making, and it's natural to get involved in policy debates. I see this I think from the management, at least in our university, this is being supported, but in general among colleagues, you looked a bit as like, this guy is, could do more useful stuff. I think that's definitely the attitude you can hear behind your back, but that's okay. But I think it should be a system to reward academics to do this, because it's actually a very difficult thing to do. It requires time and energy, and it can also backfire very badly. There is examples, I think I've been kind of lucky so far, but I have some of my colleagues who were like, in prime time on television, more or less insulted by politicians who criticized them personally with personal attacks, and then you have no defense anymore, right? You never get to answer in prime time. So it's a very dangerous thing to do as well, to get involved in this policy debate. But I think we should do it, because who else will do this? And definitely it's very good we have a lot of NGOs and societies to get involved, to help us, who probably are more experts and have more time. I think that it's always a problem, of course, of time as well. How much can you do as an academic? We have too many jobs. I guess we're all familiar with that as academics. But I still would argue that we have to spend some of it for the common good, and try to get involved in public policy, either by developing technology, or at least explaining it to the broader public, to see what we can do and to try to explain what's happening in the debates.
Unfortunately, speaking of time, we're running out, so any final comments, Chelsea?
Yes, I have many final comments.
Just shortly.
Okay, short comments. Okay, cool. Well, thank you for having me here in Belgium. This is my first time in Belgium. I have. It's been quite a wild ride these last few years, and I've been able to travel to many places, and somehow Belgium and Brussels did not make the cut until now. So I'm excited to be here for the actual privacy conference, and I guess my final thoughts are going to be along those lines of thank you very much for your time and listening to me.
And for everyone that wants to hear more, Chelsea will be on a panel on Wednesday. A no mail panel as well, so you can talk to her then. And I would just like to end up saying, we at Nym would like to, we're trying our best to support the public sector and activists and academics, even though we are a private company. And I think it's important to remember why privacy is important. So privacy does not exist it's not necessarily against power as such. Privacy is the ability, as put by Eric Hughes, is the ability to selectively disclose yourself to the world, to reveal who you are in a way that you have control over, and that gives you agency and dignity and autonomy, and that we cannot have these values that, as a society, we fought for so long without privacy. privacy in a digital era is under more threat than it's ever been. This is perhaps, and if, as ridiculous as it sounds, this is we are the last line of defense between authoritarianism and democracy. And I do believe that privacy does not only exist to stop the abuses of power, and there will be more abuses of power, but it exists to empower us. It's empowered Chelsea, it's empowered many people throughout the world, and to empower us both individually and collectively. So thank you, and we have another panel coming up. Take care.
Thank you.
Ja, in this Palais. Yeah. There were two on each side. I love your ring. In the Salon. No, no, we were just taking care of. You don't want water, right?
Yeah, a little bit maybe. And everyone kind of fit. I'm not taking up too much space here, I hope.
We're totally good. We're deliciously bathing in the heat of the lamps. Yeah. But in Lille, it's working now. Okay. Cool. So, thank you so much. Such a day, intense day. So, thank you to the panelists before us. Thank you to Chelsea for this wonderful event. So, I am Gianclaudio Malgeri. I am the co-director of the Brussels Privacy Hub and associate professor of law and technology in Lille. This is today a day of inauguration. The inauguration of CPDP after COVID, so the first spring edition of CPDP, so particularly excited for that. Also, inauguration of our new website, the Brussels Privacy Hub. We worked a lot at this website. You can see our new website. We can go to the next one. Next slide. Yeah, this is just because now everyone is scanning. Then we go on. I want to thank people that worked at this new, regeneration of the hub. Thanks so much to Mohamed Demirjan, our managing director, Michel van den Peel, and all the teams, Vincenzo, and all the teams that is working with us. So, we were experiencing more than 2 years of pandemics. and now the international crisis and the refugee crisis have highlighted the urgency to talk about vulnerable people. And we are taking this into very serious account. Just this week we had the Ida Hobbit, International Day Against Homophobia, Transphobia and biphobia, and the Pride Week. So as data protection people, we need to take charge of this. We need to understand how we talked about power imbalances, and higher risks for fundamental rights could be addressed by data protection law. So, who are vulnerable people? We will discuss this today. Some people are vulnerable. Everyone is vulnerable. Few people are vulnerable. Is it a sectoral notion? Is it a transversal notion? Is it a layered concept? You know. So, as I was saying, today is a day of inauguration because we are also launching this new observatory, the new International Observatory on Vulnerable People and Data Protection. There is a slide, I think. Because academia needs to discuss, of course, but also to act. So we are launching today this project together with the Future of Privacy Forum and the Brussels Privacy Hub. It's called Vulnera. We want to promote a discussion and a platform for sources, events, and dissemination. Gabriela and I are coordinating this effort, and as you will see in next slides, we already have a scientific network, and we are trying to address this issue in a way as broad as possible. So, let's go back to this fantastic panel. Today, as I was saying, is a day in which we need to take into account this topic, vulnerability. The GDPR doesn't address so much vulnerable people. It mentions children. It can do more. But we have the AI Act, the new buzzword that all data protection people now is taking. So, one of the first challenges and the first, discoveries for privacy geeks was that the AI Act has specific definition and, in a way, protection of vulnerable people. So for me, it was like a wonderful news. And so we are going to discuss how the AI Act addresses vulnerable people and protects them. With this incredible panel. Sorry, I apologize for the gender imbalance, but I'm very proud of this gender imbalance. We have two institutions, academia, civil society, industry, everything condensed in this room. So, first of all, I want to introduce our panelists. We have Louisa Klingvall. She's team leader of Fundamental Rights Unit at DG Justice at the European Commission. Then we should have online Brando Benifei. No, okay, maybe he will join soon. He's the co-rapporteur of the AI Act and head of the Italian delegation of the Social and Democrats at the European Parliament. Then we have Mireille Hildebrand, professor of law at the law faculty of Freie Universität Brussels and at the science faculty of Radboud University, co-director of LSTS and lead of Cubicle project. Then we have Gabriela Zanfir Fortuna, vice president for global privacy at Future Privacy Forum, and Ivana Bortoletti, chief privacy officer at Wipro and affiliated researcher at Oxford Internet Institute. So we don't have a lot of time. We will try to make the best of our time. And sorry if I already stole some minutes. So we are going to have 2 rounds of very rapid inputs, and then we try to open for a Q&A. First of all, as I was saying, the Artificial Intelligence Act proposal addresses vulnerable people in 2 parts at least. In the list of prohibited practices, it's prohibited to exploit vulnerability based on age and disability, and in the high-risk list, the European Commission could take into account also vulnerable people, defined as an imbalance, people in an imbalance of power, knowledge, etc. I will start from Louisa Klingvall, because, of course, the proposal comes from the Commission, so we would like to first give the floor to the Commission. Louisa, how does the European Commission proposal defines and protects vulnerable people in the AI environment. Is it satisfactory? Can be done more?
Thank you very much, and thank you very much for allowing me to partake in this panel. I have to say, faced with the expertise, I am feeling slightly vulnerable. But let me try to explain a little bit the thinking about this proposal. So, in a way, I don't think the AI Act specifically addresses vulnerability. I mean, you will know that it addresses the possible adverse effect of the use of AI systems on safety, health, and fundamental rights. But of course, it takes into account vulnerability in many ways. So, and it's not limited to protecting individuals that by their real or perceived characteristics could be considered vulnerable. I think, as was mentioned already today, when it comes to the use of such systems, we could many times all be vulnerable because of inequality of arms as it is between, we don't have the same information, of course, as those that use the systems when it's directed to us. The proposal corresponds to a risk-based approach. I mean, this all has to be proportionate. It's imposing obligations on industry and providers. It should only impose such obligations to the extent necessary. So, with the exception of very, very few cases, the AI Act doesn't prohibit the use of AI systems. Rather, it makes sure that when AI systems are used in high-risk areas, certain, in particularly documentation, testing, and kind of auditability requirements are put in place so that we can make sure that AI systems are crafted but also implemented in line with fundamental rights obligations. So, outright prohibitions are obviously a very blunt instrument. Nevertheless, we have a couple in the Act, including in Article 5b, that prohibits placing on the market of AI system that exploits any of the vulnerabilities of a specific groups of persons due to their age, physical, or mental disability in order to materially distort the behavior of a person pertaining to that group in a manner that causes or is likely to cause harm or psychological or physical harm. So this prohibition was justified in the impact assessment as because of the increasing power of algorithms to subliminally influence human choices. And this prohibition was also consistent with a number of recommendations of the Council of Europe and the UNICEF. Then we have the kind of thrust of the obligations under the Act that are rather focusing on the use of AI in high-risk areas. So what is high-risk areas? So here we're talking about the possible adverse effect or impact on fundamental rights, and this is the key objective to protect here. And this would, of course, include pretty much the whole catalog of fundamental rights as we know them: rights of the child, rights to an effective remedy, rights to a fair trial, right to consumer protection, human dignity, right to private and family life, etc. So with the AI Act, we have tried to identify the areas where AI systems could be used that pose a high risk to harm to fundamental rights of persons, taking into account the severity of such harm, but also the probable occurrence of such harm. And using these parameters, the proposal identifies a number of areas in Annex 3. And these areas contain a number of situations where also people are vulnerable, either because, for instance, in the field of recruitment, certain groups are already vulnerable in recruitment procedures. And obviously, the use of AI could even further exacerbate the risk of bias and discrimination in these fields. But then, of course, we also have the systems, for instance, when AI is used by law enforcement or in migration or border controls, where the impact on the individual is very significant. There is a big difference in a big information asymmetry between the parties, and where I believe everyone is actually quite vulnerable in the use of these systems. Although, of course, we know that also in the use in these fields, there is a risk of bias and discrimination on protected ground as we know them. Of course, EU law always have to be evidence-based, so the list of high-risk use cases in Annex 3 were really those systems where there had already been evidence of such risks manifesting themselves, or that such risks are likely to occur. Obviously, this regulation needs to be somewhat future-proof, which also allows this list to be extended. And when assessing whether to update the list in Annex 3, the Commission need to again look at what is the significance of the risk and the likelihood of occurrence. And Article 7 of the proposal contains a number of factors that should be looked at in particular. And there, the potential or the extent to which there is an adverse impact on persons that are in a vulnerable position in relation to the use of AI systems, in particular due to imbalance of power, knowledge, economic and social circumstances, or age, is one of the criteria that should be looked at. So this is a little bit display of how the architecture is put in place in the proposal to protect vulnerable persons. Thank you.
Thank you very much. You gave us a view of how this complex tool, as the AI Act, also takes into account vulnerability of humans. I think now we have maybe Brando Benifei, because you texted me. No, okay. So we go on with Mireille. We just touched upon this point, the definition of vulnerability in Article 7. I think it's one of the most advanced definitions that we have in the legal order in Europe. It's imbalance of power, of knowledge, and so on. I wanted to ask Mireille, she has a background as a philosopher and as a lawyer, how do you see this definition, power imbalance? Is it consistent? Are you optimistic? How do you...
I'm an optimist by nature, as you know, but also a realist. So I would like to make two preliminary remarks, because this concept of vulnerability, I think, is very important. The first thing I want to say is that as human beings, we are all vulnerable. So people who think they are not vulnerable, and that this is about others, are dangerous people. I also think that our vulnerability distinguishes us not from animals, but from AI systems who are not vulnerable, and that makes a difference. So you can break it, you can finish it, but we don't call that vulnerability. And systems that make decisions or that behave themselves in a certain way, that are not vulnerable, that have nothing to lose, are only for that reason systems that are high risk and must be kept an eye on. The second thing is, and that's also why I like the definition that you're asking me about, is that AI systems, especially the data-driven systems, so the machine learning systems, can make us vulnerable in new, different ways. And those new, different ways are often invisible. And that is because we're here not talking about traditional groups being vulnerable, like children, and all the other people that are protected by discrimination based on prohibited grounds. We're here talking about groups that are created, So groups of people that are totally unaware that they have anything in common. And what they have in common is actually established by way of very complex math and statistics. And you can raise a lot of other questions about that, but my point is here that there are new ways of making any of us vulnerable. We should realize that. And then, of course, there is the third point, that we all know that the fact that there are new ways of making all of us more vulnerable or suddenly vulnerable will have a bigger effect on the people who are already vulnerable. Now, I've said the word vulnerable so often that let's look at the definition that is in Article 7, which I think is extremely interesting, and I'm very positive about it. It's about asymmetries. It's asymmetries in terms of, what is the exact definition? Power, knowledge, economic or social circumstances. That's sort of everything, right? And then suddenly there's also age. I think age is also a social circumstance, but never mind. Now, let's quickly pick out some interesting points. The first thing that I noticed when I was reading it is that the asymmetry that this is talking about is between a natural person, doesn't mention that, but it seems to be the case, and the user of the system. Now, there's a lot of criticism on the AI Act, because the AI Act seems to put all the liability on the provider of systems. They have to take care of everything. They also have to take care of the fact that the users have to take care of things. But here you see the users. So that is, for instance, we're not talking about end users, of course, immigration authorities, law enforcement authorities, recruitment firms, banks, insurance companies, universities, private, public sectors, all those users. The Act is talking about an asymmetry in terms of power, knowledge, economic or social circumstance. Now, when I look at Annex 3, then we already see this imbalance between users of these systems and, let's say, natural persons. As we all know, fundamental rights are in the first place to protect natural persons. There are systems intended to be used by children, especially when we're talking about personalized education, also students, assessment of students, also when they are assessed in terms of admission. There is, of course, the eligibility of natural persons for health and life insurance, all systems intended to be used for political parties, political candidates, etc. There is special protection by qualifying these systems as high risk in relation to elections. And then there are two types of systems that generate either text or other media, so audio or pictures, images, that look like they've been written by a human person or created by a human person. As we probably know, there are dedicated transparency requirements for that, but they have now also been put as qualified as high-risk systems. Think of immigrants facing AI systems. Think of illegal immigrants. That's typically a very vulnerable category. So they are qualified as high-risk systems here. And I would personally say, because of my inquiry into legal technologies, at this moment, only the use of these kind of technologies by the courts, the judiciary, is qualified as a high-risk system, but I think it's very important to take that further. Law firms, public prosecutor, all sorts of publicly available apps that anybody can access to assess their chance to win a case. These systems are going to have a huge impact on legal remedies, on fair trial, on what the law can do for you. So they should all be under high-risk systems because they make us very vulnerable.
Thank you very much. So the idea is, you see, this tension between a general definition, which is something very ambitious, and the case-by-case, bottom-up cover of many vulnerabilities. So finally, we have Mr. Brando Benifei. He's the European Parliament co-rapporteur of the AI Act. Brando, if you can hear us. Yes, you can? Okay.
Yes, yes, I can. Yes.
How does the European Parliament judges the definition of vulnerable, the protection of vulnerable people in the AI Act, and how you think the Parliament is going to amend eventually that part?
Well, first of all, thank you for this opportunity, and I think it's very important that we have this very intense discussion in these weeks when we are finalizing the amendments proposals from the European Parliament, and also in the Council we are having the same discussion on how we ameliorate the text that has been presented already more than 1 year ago by the Commission. And now we are in a phase where by proposing amendments and then working on compromises, we are going towards having a final text, hopefully at the beginning of next year. This is what we are willing to pursue. On the topic specifically at the center of the discussion of today, I would say that there is no clear definition, but rather we are trying to strengthen through amendments that we are going to present. I'm sure it will not be just me, but also other colleagues, to put clearer references, like adding categories like sex, health, psychiatric problems in the biometric data categorization, and in general trying to go down the same direction that we started with the report that I co-authored with my colleague Dragos Tudorake, where we put already, for example, the everything having to do with children and their cognitive development to be put into the high-risk categories. In general, I think that by putting amendments regarding human rights impact assessment, for example, we will try to do what in general legislation is there for, to protect those that cannot protect themselves with other means, different from a legal protection. And so we are going to go in this direction. I think the Parliament has to play this role also in the institutional balance with the Commission and the Council, because the perspective of the single person, of the individual, especially the vulnerable one, is the one that the Parliament takes, I would say, as a natural position. So to conclude, I think that getting more into the categories that are better identified, because today in the original text there is not clear definition, and also putting means of, we can say, verification on protection for vulnerable groups. So the human rights impact assessment, I think, will be crucial. But finally, also on the side of the redress and enforcement, we need to be sure that there are strong redress mechanisms and governance structure for enforcement that are able to do their part, so that in front of infringements we can avoid any case like the famous Dutch case that we always make as a reference, of algorithms that can destroy families, and then we cannot expect a long legal battle to restore the right, in this case, of children to be part of their family. So I think that with all these aspects, we will work on amendments. We will work to strengthen the text that we have today from the original draft of the Commission. Thank you very much.
Thank you very much. So if we understand correctly, the approach is more methodological. So we see the human rights impact assessment as a step forward for the AI Act. And Mr. Benifei mentioned the Dutch cases in which students sometimes are exposed for their vulnerabilities. So going to our next panelist, Gabriela, FPF just published this report on cases about automated decision making, and cases is the first step, maybe where we need to start. So what do you think of these cases, the definitions, the list of vulnerable people that cases addressed? Also looking at US, because at this table you represent US too. And please speak close to the microphone because we had some audio problem before. Okay.
Thank you very much, Gian Claudio. And hello, everyone. It's such a pleasure to be here back in Brussels at CPDP. I really loved what Mireille said earlier. She said that as human beings, we are all vulnerable. And I think when we are thinking about vulnerability and categories of vulnerable people, categories of vulnerable groups of people, we should always keep that in mind. At one point in time, we will all be in one of those vulnerable categories. So then, of course, the question is it really useful just to have a finite list of vulnerable categories of individuals and groups that we want to protect with new legal tools? Or do we want to perhaps complement that list with frameworks, like a legal framework and tools that will help us identify at the right moment in time, depending on context, depending on societal problems, the vulnerable groups that need protection at that moment. And I will give you an example from the United States where currently, frankly, women of age that can be pregnant suddenly became a very vulnerable group in the oldest democracy in the world, right? So that's, in order to deal with this kind of situations, I think the answer must be somewhere in the middle. A list, very thought out list of vulnerable groups and people, but then also the mechanisms and tools to be able to identify new such categories that appear. So I was very happy to hear Mr. Benifei mentioning this second approach. Before giving the floor further, I just want to point out that there was a particular provision that also struck me from the AI Act as being very much linked to vulnerability, even though it's not prima facie linked to it. One of the obligations for those that create high-risk AI systems is to only rely on data sets to do training, validation, and testing data, where data sets shall be relevant, representative, free of errors, and complete. And I want to focus on representative because this means that the data sets that have to be used for the high-risk AI systems, all of them, must be inclusive, right? So in this representation and inclusivity, I also see a way in which we can tackle vulnerabilities that are not apparent at this particular moment in time in 2022 when this legislation is being discussed. Thank you.
Yeah, and I think you made the important point, the mission of our new observatory, trying to observe what's happening, trying to find like corpus of what's happening in terms of vulnerable people around the world, and in particular looking at data protection, whatever vulnerable means, but getting a broad approach. Now going to Ivana. Gabriela mentioned the issue of women and age, and you are also part of Women in AI. So how could, in your view, looking at gender issues, intersectional issues, how could the AI Act be improved looking at these aspects?
Thank you so much. And first, it's absolutely great to be here and to be on a panel with people that over the last few years during the pandemic have just obsessively followed on Twitter. Now I'm sitting next to you, and this is absolutely amazing. So I just wanted to start with that, and Brando, of course, and all of you. So it's brilliant. So I just wanted to start with a thing, because I just feel like you've said so much and so beautifully, as always. But I just wanted to say, it is true. I mean, I do agree. You know, vulnerabilities, we're all vulnerable. And this is why, you know, this is what data protection is all about, ultimately, you know, because we want to resist those asymmetries and put in place the tools to resist those asymmetries. Nevertheless, I do think that there are some people who are more vulnerable than others. And in particular, there's one element that I am concerned about, which is the element of intersectionalism, and how we live in a world where, particularly with these artificial intelligence systems, it's very difficult to understand where discrimination may come from. I mean, Professor Sandra Wattke did a fantastic work on this, on how different vulnerabilities may adapt to each other, and make it even more difficult to be understood, tackled, especially in the opacity of many of these systems. So what you have at the moment is that you have somebody who may be discriminated because they are black and they're gay, because they are disabled and they're black. And I do think this is a very serious problem that we're facing. And in these systems, we've got to understand how we're going to safeguard for this. Now, I came into privacy from a human rights background, but before the human rights background, I came to human rights from a feminist background. And I grew up with the idea that there are some very important principles that have guided my approach so far in terms of what it means from an intersectional and feminist approach to privacy, to what that means. And to me, these are, and I have to list them, agency, equity, social justice, fulfillment, empowerment, and identity. So I'm really pleased to hear when Brando says we need to make sure that from a methodological standpoint, for example, we made the human rights impact assessment an important part of ensuring that at design stage, we take into account the sort of the possible extent of vulnerabilities, because vulnerabilities, you know, they come from different reasons at different stages of life and all of that. But it's really important to me that we try and codify as much as possible an intersectional approach to this. Mm-hmm. And we ask ourselves, which identity are we talking about? Does this identity intersect with another identity? And how can we make sure that we can cater and support and safeguard all this the different elements of vulnerability that create us and make us as human beings? Because Mirelli's right. I mean, there are so many new vulnerabilities that we're subject to and then emerge because they are created partly because we're already vulnerable and we may be in a particular category, but also because these systems, through big data and computation, they create and add new vulnerabilities to the ones that we already may have. So I think is having this approach, I think, is really important, and ask ourselves and include and make that part of the act around human rights impact assessment, how we define those human rights impact assessments, how we are able to frame intersectionalism as part of this human rights impact assessment. I think, to me, from a sort of the background that I come from, that is really, really important.
Thank you very much. I think very key points. Now, I know that Brando needs to go soon, so I will ask him the last question. And it's very, policy question, practical question. What can you foresee for the destiny of the proposed European Parliament amendments on this topic, or in general, next steps? Tell us.
Well, that's a big question. I think that we can expect resistances from the Council side on various points that we touched, because they, with difficulty, the Council, so the governments take the individual human rights approach as their approach. I've seen it also in other negotiations. But I'm sure, and I already talked with many governments, that we can build some constructive dialogue, and it will be important to have a strong and fruitful negotiation to enlarge the protection for vulnerable groups, so that we come out very strong from the Parliament side. So I think we will need to be precise, not too confused in terms of touching too many different aspects, but to be clear, but straightforward, but also very strong on these aspects from the Parliament side. I'm convinced we can have a majority in the European Parliament for a very thorough enhancement of this text in the sense that we discussed. And then we will come with this strong text to the negotiation with the Council. I'm sure that a good result in this way will be ensured. If you are not clear, you will not be taken seriously. This is what I learned in politics. So we should not be muddling. We need to be clear on our principles, and that is that we do not want any AI to be deployed in with the risk of making lives of vulnerable people worse. We want, instead of AI being an emancipatory factor, we want that to be our model of AI. And if we go clear with that, also with the legal technicalities that are needed, I'm sure that we will have a good negotiation that will deliver on the most important issues. Personally, I think that the human rights impact assessment will be extremely important, as well as having a very clear and functioning forbidden on the surveillance practices, because I know that will be a hard discussion with the Council, but I think we should avoid any form of surveillance society to be brought in, because that will be also very much damaging for human rights defenders of vulnerable groups, because surveillance means putting in a weaker position those that defend vulnerable groups from being discriminated. Thank you very much.
Thank you so much. So yeah, you addressed very important points, the human rights impact assessment. The question is now how to do that. We have an audience of people, expert of DPIA. We can wonder whether DPIA is a good example. This would be a topic for another 2-hour panel, another panel, which is maybe many in the next days. So now we are going towards the end. We have 20 minutes. As Paul Dart was saying, this is the chaotic part of CPDP, so for me it's a hard role. I know that we are the obstacle between you and the cocktail, so we will try to make it effective. Now, I would like to ask, again, Brando said we have to be clear. I know that there is time for amendment till the 1st of June, so push your European Parliament member to propose something to amend the AI Act as you wish. Then, let's go. Just if you can reply just in 2 minutes, then we try to have a short Q&A. So I wanted to ask to Luisa Klingvall, some criticisms were raised. For example, the fact that the blacklist of AI just includes age and disability. The Council proposed to amend it, but still. And also the definition of vulnerability that Mireille was referring to is up to the Commission to amend the high-risk list. So my question to you, is it realistic that the Commission will protect more the vulnerable people in the future, looking at Article 7? And how do you look at the criticism or discussion about this?
Thank you very much. I think that we have to look at this. The AI Act is part of the toolbox to protect fundamental rights. It's not the fundamental rights protection instrument that we have at hand. So, essentially we have at EU level a whole host of acquis that protects fundamental rights, in the field of asylum, migration, in the field of non-discrimination, in obtaining services, employment, etc. So the idea of the AI Act was not chiefly to establish new rights or new protection as such. It's more about ensuring that the systems that we have in place already to protect fundamental rights can be enforced, because, of course, the difference between AI and other technology is the opacity. So it allows us to look under the hood of this technology. And that is also a very important provision of the AI Act, which is often forgotten, is the ability of those enforcement authorities that are in charge of enforcing any rules that pertain to fundamental rights to access the information that the providers have to put in place. So the AI Act has to be seen in the context of the overall stack of legislation we have at hand. And of course, this could be legislation at national level as well. But clearly, I think moving forward, I mean, at EU level, I mean, we are looking also at the acquis we have in place. I mean, the consumer acquis is being looked at now. There is a refit ongoing to see if any further specific protection of both types of vulnerabilities in terms of grounds, but also situations should be covered. And I mean, EU law protecting fundamental rights is continuously updated to this effect. So I think it needs to be seen in this kind of grand scheme of the whole toolbox. Thank you.
Thank you very much. And just on that, I wanted to ask to Mireille, looking at the interplay of the AI Act with all this context and acquis, what do you think? Do we have, I know it's a mission impossible in 2 minutes to say if the whole EU law protects adequately vulnerable people, but your flash view.
Yeah, in security, digital security, there's something called buffer overflow. So you give the system too much and it creeps in the rest of the system and begins to manipulate. Sometimes I feel that's what the Commission is after, giving us, anyway. So the question is too big. I'm going to restrict myself. But the first thing I want to say, this is a point made by Michael Veal, and I think it's a worrying point. The idea of the AI Act is full harmonization. The only thing that really gets regulated is high-risk systems. Now, that would mean that systems that are not qualified as high-risk systems can no longer be regulated by the member states. I think that's a really bad idea, and I would actually like to have a response from the Commission, but maybe that can come later in the discussion. I think in terms of vulnerability, when you look at the GDPR, there is some overlap between Article 22, the prohibition of automated decision-making. I'm looking specifically at public administration that is overwhelmed by a religious belief that the government cannot do without digitalization and taking a lot of decisions automated. In any policy thing, the first statement is we should be so grateful that we have all this automation, because otherwise the government will strand. And I would like to give as a message, well, I don't know, because this is legacy, this is maintenance, this is security issues. We have very old laptop computers or other computers working in the government that are not supported anymore by operating systems because they are they have to be used to run very old systems that cannot be taken out because then the whole system crumbles. So we have to think before we believe this. When public administration makes certain decisions, there is an assumption that that's lawful. So here, every citizen is very vulnerable towards the government. Now, the threshold for Article 22 decisions is quite high. They have to be solely automated, et cetera, et cetera. Then I look at the overlap with the AI Act. The AI Act that very clearly has very different objectives. So the overlap has a different purpose, but I think it is extremely important to keep the definition of AI systems very broad. So not only machine learning, and not only complex AI systems, because otherwise there are going to be big gaps. My position is, for instance, and then I will stop, so much more to say. My position, for instance, is an Excel sheet in itself is not an AI system, and it shouldn't be qualified as such. If that Excel sheet, and we all know that that's the most used software in the world, if such an Excel sheet is used to determine your tax application or your right to social benefits or whether you're going to go to jail or how long, and we all know that these systems allow to calculate, then it should qualify under the AI Act so that all these quality requirements, the risk assessment that is required, the data governance, applies. And I think here the complementarity of the AI Act and the GDPR Article 22 are extremely important. And of course, competition law.
Yeah. And thank you. Being on the GDPR, I wanted to ask both to Gabriela and Ivana, but let's start with Gabriela. Looking at the GDPR, do you think that the interplay between the AI Act and GDPR on vulnerable people can be exported outside the European Union? Do you see room for some international protection of vulnerable people? 2 minutes.
Thank you for that, Gian Claudio. We already know that the GDPR has been kind of exported all over the world, and we have frameworks that look more or less like it in literally every region of the world right now, including the United States, at state level in 5 of the states of the US. Exporting this particular topic and intersection is going to be difficult. There are some very difficult conversations we're having, for example, among ourselves colleagues working with Europe and then working in the US, where we're talking about vulnerability, and our American colleagues are telling us, well, we don't really have a good sense of what that means in our context. We are looking at marginalized people. And when we're talking about marginalized people, that technically means that they are marginalized by someone, right? Whereas vulnerability is about being vulnerable by yourself as a consequence of who you are. So there are some very, very difficult conversations that take place among these different perspectives and visions around the world, and I am so privileged to be able to work on a daily basis with our teams in Singapore, in Tel Aviv, our colleague in Nairobi, and this type of very sensitive topics are really manifesting themselves differently depending on society, on jurisdiction. I will give you just one example. Think of India's proposed Data Protection Act and its list of categories of sensitive data. And on that list, there's, for example, caste. Now, this is, a situation that it's not easily translatable in other jurisdictions and how to deal with it.
Yeah, I would borrow a term from computer scientists. There is semantic interoperability problem between different US, Europe, and other legal systems about vulnerability. Ivana, as a researcher, but also as a chief privacy officer, how do you see the overlap between GDPR and the AI Act, also in the protection of vulnerable people?
Right, so I just wanted to say, you were completely right, but the way that you position sort of the interaction between when we were talking about GDPR and Article 22, and I just wanted to make one point, and that is that yes, I mean, GDPR has been exported in a lot of places. I work mainly in Asia with an Indian company, so and spend most of a lot of time in between sort of India and other countries there. But what I wanted to say is that what is really strange that is happening, I find, and I don't know if you agree, but there's a sort of an incredible alignment to an extent that we're seeing, right? So we are seeing, for example, the GDPR Article 22 or similar we're seeing an alignment. We're seeing this in legislation across the world, right? With all the nuances at local level, obviously, because India is different than the US and everything. So there is this alignment that we're seeing. At the same time, there is a major disalignment that we're seeing on many different issues, including data localization. But at the same time, what we're facing with, especially in the business world, is we're facing with the big elephant in the room, which is, we've got to compete. We are in Europe, we have to compete, we have to, we have to drive this competition, we can't, which is also a point, right? However, what I think is that in Europe, for example, we know that tackling the gap between sort of tackling vulnerabilities is part of what we consider as growth. It's part of, it underpins, the fundamental rights and the way that we live in the EU. And GDPR, to an extent, does reflect that. Article 22, access rights, there is a lot in there that reflects that. One thing that I would always question to the GDPR is, for example, how it makes data protection impact assessment so underused. Because I would have liked, the fact that it says where appropriate when it comes to DPIA, and the fact that DPIA need to be, can involve different communities, including vulnerable people, that could be more of a negotiation, deliberation process, but the GDPR makes that as where appropriate. It was diluted, wasn't it? It would have been much better if we have, this is a DPIA by negotiation where they were enshrined in a much stronger way into legislation, because that would allow us to create a much more sort of to care for sort of vulnerabilities by involving vulnerable people in the first way, which is I think is absolutely important. I have to say that, at the time of bashing of GDPR, because we've seen quite a lot of bashing of GDPR in recent times, I do think, as you, Gabriela, proved in your report, that GDPR has been great at standing up for and upholding people's rights in the age of AI. So I am actually with hoping that, what Brando was saying, I'm hoping that the two together, plus competition law, plus human rights law, plus non-discrimination law, plus consumer law, we can safeguard and uphold people's rights. On vulnerability, there is a little bit more to do, but we can uphold people's rights. That's why your work was so important, and everybody should read it. Please read it. It's really sad. The GDPR, with all the bashing, I'm sorry, but with all the bashing over recent times, it stopped applications, no apps have been produced, but reality is that there's been a great legislation in upholding these rights in an age where data protection authorities, consumer authorities, a lot of them have been navigating in the dark about how to deal with the nuance. So I think, like Mirella, I'm an optimist, realist, but optimist.
And you raised a great point. If you go to methodology, and we want to protect vulnerability from methodology, we need the multi-stakeholder participation. The DPIA is not adequate on that, participatory design. And since we want participation, we have a few minutes for your participation. So if you want, we can collect, I think, 2 questions, 2-3 questions, very short questions, and we try to reply. Yeah, there are microphones there. So while you go to the microphone, first arrived, best served. I remind you that the AI Act will be the topic of today's panel after lunch, and Wednesday last slot here. So there will be a lot, and many more. These are just the ones that I'm aware. So yeah, the question. I don't know if it works, that microphone. Try.
Maybe you can also...
yeah, I will repeat for the record.
Great. Thank you very much for a great panel. I have 2 questions. The first one is on gig economy workers and to what extent the AI Act might give them new rights. And the second question is also on the enforcement mechanisms. So how concretely does that maybe look like from a user experience point of view? Thank you very much.
So the 2 questions were, one about gig economy, how platform workers are affected by the AI Act or can be better addressed with the new directive. And the second was about enforcement of AI regulation. Then we have another question.
Thank you very much for the great choice of topic today. And my question relates to the definition of vulnerability in the context of harms, because in Artificial Intelligence Act, there is a mention directly to the physical or psychological harm. And I'm interested in particular context of manipulation, for example, where autonomy is violated, but there is no psychological or physical harm experienced by, so subjective experience is not there. Does AI Act allow such practice? Thank you.
Okay, so the second question was about the relation between harm and vulnerable people in the AI Act. If I can just rapidly reply to that one, the exploitation of vulnerability is likely to produce harm in the Article 5. So there's a broader view on that. Yeah, but it's just for agent disability. So yeah, there's this problem. So who wants to reply to one or two of the questions? Mireille.
Can I add something to the last thing, last question? So I think the fact that individualized, identifiable harm in the prohibited AI practice, as it's called, not AI system. So any AI system, if it becomes part of a prohibited practice, will be prohibited as that practice. Some people think there are 3 categories, but they actually overlap. I think that requirement of individualized, identifiable harm is a far too high threshold. We all know from liability law that many of the societal harms cannot be proven in that way, so that's a very difficult one. But in Article 7 and in Annex 3, you see that many of the systems that aim to, or that have potential consequences, negative consequences for vulnerable people, are qualified as high-risk systems. And that means there is a whole lot of protection, but that protection is at this moment not in the form of individual rights. And yesterday we were discussing the wonderful report that was written by, I haven't said it, thank you for mentioning it. This is about enforcement of Article 22 in real life. Fantastic report by the Future of Privacy Forum. And now, of course, I lost my thread by discussing this.
And if
well, I can add to that. So perhaps, and it replies to the question on gig workers. Actually, I have not seen particularly gig workers addressed in the AI Act. However, workers are addressed generally in the category of high-risk AI systems. So that's definitely something to consider. And speaking of the report, I would also invite those of you curious about it to look at some of the cases we summarized, particularly the Fudinho case in Italy, the Deliveroo case as well, partially the Uber cases and the Ola case in the Netherlands, and just see at least, in the Fudinho and Deliveroo cases, the type of very complex analysis that the Italian courts and the Garante, the Data Protection Authority, have done to apply the GDPR existing tools to the situation of gig workers. And we were also surprised, to be honest, to find that level of analysis.
Yeah.
So
in the Italian case was interesting when the Garante said the consent cannot be
valid because it's not sufficiently informed, because
exactly.
It's not, the logic involved was
so
not
explanation
explained.
was connected to lawfulness.
Exactly, and that reminds me to one thing. We're saying that this law, the UI Act, is not the universal law of AI, right? It is one. Nevertheless, and in fact, there is the European Commission proposed the platform directive. Oh, yeah. And that is really, really important, because basically says that workers in the gig economy and also independent workers, they have the right to context the algorithm. There is a right to transparency. Now, the key thing would be how to make that transparency meaningful, but that's another question. But I think...
So let's hear the Commission.
No, just to kind of underline what you were saying now, I think that is a typical example of how this jigsaw puzzle interacts. And clearly the platform worker proposal deals with some of these very thorny questions of the status of a worker, who is a worker and who is an independent, and what access to information you will have. And my colleague Eike, who's sitting here, I think will be on an interesting panel on this topic in the coming days. So I'm sure he will tell you all about the interactions of these two instruments.
Thank you very much. It was incredible. But there is another obstacle before the reception because we have the final speech by Joachim. Is correct? Yeah. Yeah. Oh, okay. So it's not the end. So thank you so much. I hope I learned a lot. So much to organize in my ideas. Thank you to these wonderful panelists. Thank you to Brando, who was engaged with political activity around Europe. And thank you to all of you for your question and your participation. Now don't escape because we have a last thing.
Yes, we do have a last thing. So thank you all. Thank you, Gian Claudio, for moderating this panel, and to all the speakers. And thank you again to Nym Technologies and to Brussels Privacy Hub for co-organizing this special opening event with us. Before we let everybody going into the cocktail reception, Akim Klabunde will just say a few words of closing remarks. All right? Thank you.
Thank you very much, Bianca. Let me just get my notes out and check the microphones on the way. Yeah, it seems to work. I cannot see you because of the bright light, but I saw many known and friendly faces on the way in. So I'm very happy to be here. Very grateful to the organizers for inviting me to do this little remarks. It was a bit funny when I first told a friend I've been invited to do the closing remarks at the CPDP. The friend went, "Oh gosh, the closing remarks." And I said, "Well, hear me out, the closing remarks of the opening event." The other one is still reserved for the actual European Data Protection Supervisor, who will do that on Wednesday. So, but I had the pleasure of the honor of being mentioned in the closing remarks of the supervisor last year, because that was also my last day working for the EDPS, ending the professional part of my career in data protection. And my career in data protection actually started like 50 years ago this year. I cannot put it on a day, but it was back in 1972 when I started reading about data protection in German scientific popular scientific magazines, which I was reading as a young student, and just also at the same time when I had my first experiences with computers, when I was writing my own first computer programs, and then I was reading the stuff about data protection, that computers weren't just super fascinating and a coming thing, but also quite dangerous. So that was certainly a challenge at the time to understand this and to get into that, and somehow the topic never left me. I was first an interested citizen, then an interested student, but focusing on computer science, but also on its social aspects, and on a computer science professional. It never really was quite sure that there were more things that should be taken care of than the business would think of. And an activist in data protection, and then one day I became an EU official, and after 4 or 5 years I found that I could do data protection full-time professionally. So that was, of course, kind of a fulfillment, completion of this part of the career. But that ended on the last day of CPDP 2021, when I retired from the European Data Protection Supervisor. And well, I tried, when I thought about what I was going to say, I was thinking of kind of all types of funny remarks, but then people told me, "You're German. Don't try to be funny." That's not going to work. So I'm trying to follow this advice. So, but every now and then, when my leaky memory still has things from back in 1972 and the following years on my mind, then I often see it in today's discussion that many people, of course, weren't around and not involved in the discussion at the time, and many people seem to have forgotten what was the ideas then and why they were what they were. Like, what were the things which have survived from the 1970s, from today? Well, one thing, of course, is the term data protection, the somewhat unfortunate choice of the term data protection, or Datenschutz in German, because just read the full title of the GDPR. It's not about protecting data. The full title of the GDPR is actually protection of the fundamental rights of individuals with respect to the processing of personal data. So data is in it and protection is in it, but this is kind of like taking the first and the last word from a very long concept and just putting them together because it's such a nice shorthand. But that's not what it is about. The GDPR also has a second name, and the free flow of such data. So that is why it's the GDPR, why it's an EU instrument and international instrument. Because one thing that is also survived from the first data protection laws in the 1970s is that everybody knew that it is so easy to move the data and the data processing somewhere else, where the people whose data is processed and the authorities authorized by them have no way of controlling, supervising, enforcing anything. And so it was forbidden to move the data abroad, outside of an area of data protection. And that has, of course, created the problems created through the limitation of data moving around the world freely, has created this wonderful international community of data protection experts who think about safe harbors and privacy shields and safe privacy harbor shield frameworks and the next generation for the last not 50 years, but someone can recall me when the OECD convention, COE convention, Council of Europe Convention 108 was established. I think it was like the early 80s. That was kind of the way to overcome this obstacle which was created by each and every national data protection law which was adopted, like in 1978 in Germany and in France and later in some other countries. And everybody didn't want data to move around freely because then it would go away from decent supervision and enforcement. The funny thing is, a few other points was the principle, which we still find in the GDPR, processing of personal data is forbidden unless it is explicitly allowed by the data protection law or some other law. Well, that has been found to be a very strange concept by some, while at the time it was just seen as a legal technical way, because it would have been far too difficult to write down all the ways that should be forbidden. So it was much easier from an amount of letters point of view to say it's forbidden unless it is allowed, and then you have now developed the 6 reasons that can create allowance, and of course they have also been developed and drilled and extended and restricted and interpreted and reinterpreted in many, many other ways. What we also have since the first concepts of data protection is the independent supervisory authorities, but probably the idea that any authority could supervise all processing of data that happens in their area of jurisdiction has never been so untrue as it is now, and it is not going to change in the positive change. But there's one element which was kind of quite revolutionary and surprising at the time, and that is that data protection limitations apply both to public bodies and to private entities. I mean, from a traditional liberal democratic European perspective, restricting the amount of power that the state has about its citizens was quite obvious. I mean, you could go far to the center from the left and far into the conservative line of thinking where this idea was popular. But to also limit what private companies can do with their clients' data, with consumers' data and so on, that was an idea which only could evolve in a moment in societal history when there was an understanding that social freedoms and civil freedoms belong together, that you cannot be free when you are totally dependent in an economic perspective. So that economic dependency that you have as a consumer is as bad as the citizens' dependency on the state. I mean, not bad, but it's also something that needs to be limited. And so this is, of course, also kind of a double phase of data protection, that we have the state, the police authorities, and so on. And on the other hand, we have private companies which also take advantage of the processing of personal data. If you would like to get a recent update on what the risks were that were behind the authors of the data protection laws' minds in the ideas in the 1970s, then I think don't go back, don't try to find the old reports. I mean, one of the scholars at the table, Gabriella, has done extremely valuable research going back to the report that was in the US Congress at the time, informing and later to the US privacy law, federal privacy law, and similar reports have been done in European countries and so on. But you can read much more recent papers, like when you take the first papers in the current AI discussion, which were published like 5 years ago, but were published then by different academic, political, and civil society bodies. You just take any of these papers and you replace the word AI, the word artificial intelligence in these papers by computers. And then if you do that consequently, you end up having some of the papers that were on the table in the 1970s and informed the discussion about laws limiting the processing of personal data. And this is not completely a joke. I remember a concrete paper from the UK Royal Society where I did exactly this, and at least with the first couple of chapters. And this was really like, oh yeah, I read this 50 years ago or then 45 years ago, and it's still the same. So this gives rise to a few questions in my mind. Before that, I would like to mention another myth, that data protection was developed, or the concept, at a time of societal peace and freedom, and well, in the 1970s, the Summer of Love. It was a bit earlier, but still in the spirit of people, and everybody was happy and relaxed all the time, and so there was really nobody who needed to process data. Well, it's not. It wasn't. I mean, I'm not quite sure, because I couldn't find the source today, but I'm pretty sure that the 1970s was a decade in Europe with the highest level of terrorist activity. If you have lived at that time, or if you have read about this, then you know that we had homegrown terrorist groups in nearly all major European countries, obviously in the UK, obviously in Spain, but also in Italy, in Germany, and other groups operating at an international level. And it was the time when the police was also discovering computers and developing profile-based policing in the first instruments, at the time when much of what we can do today was not yet available. I mean, I remember from the first days when I had some idea of what computers can and can't do, or could and couldn't do, because that has changed in the time. But people had ideas that would today be called big data and analytics and machine learning and so on, which wasn't possible at the time, just because the science wasn't that advanced in the algorithmic field, but also the hardware was not as advanced. I mean, hardware limitations have been a very effective limitation of the processing of personal data, just because the bandwidth for transmission, the speed of processors and other means were not so developed to fulfill all the risks and fears that were on the mind of data protection authors at the time. But And credit, among others, certainly is to Mark Rothenberg, who mentioned this already like 10 years ago or 15 years ago at CPDP. These limits are gone. Now there is no technical limitation more. Whatever can be imagined, processing is possible, and if it's going further. So we cannot rely on this anymore. And with that, I want to get back to the present, because, I mean, to come back to this contradiction of doing the closing remarks of an opening event, I mean, it's not like telling you what I should have thought and you might think, and then everybody going home, because it's not the case. You're still all gonna spend 3 days listening and debating data protection. And so I have a little evaluation of what has happened with the help of data protection, with data processing over the last 50 years. On the one hand, it has become a lot better in terms of fundamental rights protection. There's a lot more transparency than we had back then, and any time in between, so that people actually know which data they are processing, they document it. And also, of course, the security of data is, in principle, much better, even though the misuse attacks are becoming stronger as well. And we have indeed a very developed system of compliance. What we just heard about data protection impact assessments, about the different procedures. So GDPR, among other things, is also a manual how to do proper data protection. It's very practical, hands-on in some points. Sometimes it's a bit abstract, admit it, but you can't always be so concrete. But at the other hand, over the last years, processing of personal data has become a lot worse. I mean, there are things which are going far beyond what anybody was considering a risk in the 1970s, like the amount of surveillance-based advertising with all its branches of uses. And we call it advertising, but the surveillance capitalism is not limited to advertising. It's to choosing to which person you will sell which insurance contract, and which person will never get an insurance against a risk which is too likely to have them, and to take into account all kinds of data. I mean, I heard from advertisers in the advertising taxonomy are those people paying the entire advertising thing. So some other word for it is the brands that buy the bulk of the advertising capacity, say that the actual surveillance is the added value. So there's this old joke of an advertiser who says, I know 50% of my advertising budget is wasted, but I don't know which 50%. And with the tracking and the conversion tracking, so to find out exactly that person who saw this ad a couple of weeks ago now has bought the product that was advertising then. So to connect this cross-media, just by buying credit card transactions and combining it all. That's the actual value of the person deciding about the use of the advertising budget, because then they can go to the budget controller in the company and tell them, well, yes, we spent so much money, but we got 550 customers of the target group through this precise ad that we played. And whether you would have got more or less conversion success in advertising without the personal targeted advertising, that's just not feasible. That's just not measurable, because the part of the advertising which is not personalized, you have no conversion tracking, so you cannot find out what happened to the thing. Okay, we know a lot about the profile-based policing. I mentioned that, and this is all supported by increased automated surveillance with facial recognition, number plate recognition with cars, and all kinds of surveillance machines, machinery. that works partly with so-called AI components. And on the other hand, a big problem is that we have a big lack and strong limits of the actual enforcement. So the pure supervisory authority enforcement may not be fully sufficient to put the necessary limits on the processing and the abusive processing of personal data. Though it has done a lot. I mean, it's like traffic speed enforcement. Of course, I mean, there's no way to stop 100% of drivers of driving too fast in all streets. But you probably have a reduction of the high speed and the resulting accidents by 20, 30, 40 or 50% through spot-based temporary supervision of and enforcement of this. And at least in that respect, we have quite also significant success through supervisory authorities. So what I'm going to look at CPDP, new ways of enforcement. I know I don't see anybody, but I know the whole team of NEUP from Vienna is here at the conference today. I don't know if anybody's here. I don't see a hand. But of course, civil litigation, not just the administrative enforcement, that is a way which is very strong, was supposed to be very strongly supported by the GDPR, and it seems to be taking off. We also must take into account that data protection doesn't live in a vacuum, and that many of the things which violate data protection law also violate other bodies of law. So what we just heard in this discussion, the connection with competition law, with possibly consumer law and other bodies of law which play a role in this field, is also something which may bring new things. And then, of course, quite important is the political or policy or activism seen to stop feeding the data hunger of investigatory authorities. I mean, there will never, the investigatory authorities, and this is not something because there are bad people, it's just like when you want to investigate any kind of crime in order to stop it, you want to know as much as you can about this data and want to know it in a legal way that can be used in court. But of course, this will never end. I mean, even when you allow authorities to scan each and every message and decrypt each and every message, you will still have cases of child abuse which you cannot investigate in the proper way. It will still be insufficient. Some people may still think we would need more data, more introspection into what people are doing. So it will never end. And it is really a challenge to the entire society to say we have to find the balance between surveillance and freedom. And this is a very, very important day. So for the next 3 days, just keep in mind, data protection is not about data, it's about freedom, the freedom to be the person that you are, to behave in the way of a person, and it's the more difficult, the less privileged you are. Don't forget this, the less people are privileged in an economic and other citizens' way, the easier their freedoms are taken away. And just let's keep all in mind that data protection is not just a technical issue, but it is really a very basic feature of democracy. Thank you for your attention.
Thank you, Akim, for the closing speech, and I will not take up any more time, and I invite you to join us for a reception just at the back through the double doors. Thank you again to Brussels Privacy Hub and to Nym. and to you all.